Welcome to all of you and thanks for being with me here. First of all, I thanks all of you for your overwhelming response to my article and presentation. I have received large number of queries from the readers and the viewers. Based on your queries, I have created this video which covers the challenges which are being faced to the Section 65B of the Evidence Act. So the first issue which have been raised by most of the readers is whether the scanned documents are admissible in the court of law with a certificate under Section 65B of the Evidence Act. See, in the court, the documents are admissible either as a primary evidence or a secondary evidence. So when we talk about the primary evidence means the evidence which is into the original. So what would be the original in case of scanned document? Can we say that the data electronic record which have been preserved is a original? No, because we know the original is into the physical form. So once the original is into the physical form, so then the document would be proved in the court of law either by way of the original documents which is into the physical form or its copy which would be admissible by virtue of Section 63 and 65 of the Evidence Act. Because only the secondary evidence of the electronic record is admissible by virtue of Section 65B, and it is mandatory as held by the Supreme Court in the judgment of Anwar Bibi versus Bashir. And the second issue is that when we talk about the electronic record, that have been defined in the Act. If we go by the definition of electronic record or electronic form which covers the electronic evidence, so it specifically says the information which is generated in the electronic form and particularly in optical or magnetic media. So in case of scanned document, the original document have not been created in optical or magnetic media. So again, it would not be admissible as a electronic record. And the third is law specifically provide that how the electronic records are required to be retained. So the Section 7 of the Information Technology Act says that the electronic record which is being retained should be retained into the original format. So again, in case of the scanned copy, the original format is the physical document. So all these three clearly proves that the scanned documents are not admissible as an electronic record by virtue of Section 65B, but they would be admissible by virtue of the provision of the Evidence Act which are applicable to the documents traditionally. The second question which I have received is, and most of the queries are based on this question, is whether original evidence is required to be preserved after submitting the secondary evidence under Section 65B, because the issue which is being raised in most of the cases are particularly relating to the CCTV, that once you have obtained the evidence in the form of CD or printout and attaching the certificate under Section 65B, and after that, that evidence get destroyed. So now the issue is, in such cases, whether that particular electronic original evidence is required to be maintained or not, and what would be the fate of the secondary evidence which is submitted in the court of law. So see, first thing is we have to go what are the requirements relating to the retention of electronic record. So Section 7 clearly says that if we have to retain the electronic record, it must be retained in the original format. Number 2, it must be accessible subsequently. Number 3, its metadata like origin, creation, that should be preserved so that its authenticity can be proved. So when all these three options are there, and it is one of the requirements that the original should be accessible on a subsequent reference, so it clearly implies that if we are relying upon any information which the law requires to be retained, that means that should continue to be retained and subsequently can be verified, can be authenticated. So again, if we come to the section 65B, then it says production of the secondary evidence being produced in the court of law in place of the original evidence. Now, if you go by the condition in subsection 2 of section 65B, we have 4 conditions. So all these conditions are relating to the original evidence. So that means at the time of the issuance of the certificate, the original evidence should exist. Number 2, the original evidence should be preserved so that the data should qualify within the meaning of retention of electronic records as provided in section 7 of the Information Technology Act or Technology Act. Now, what is the purpose of maintaining the original, preserving the original record? So that relates to our third queries, that whether original evidence can be inspected by the accused once it is secondary evidence is filed into the court of law. So the Honorable High Court of Delhi in the case of Dharamveer versus CBI has clearly held that even if any evidence is filed with a certificate under section 65B of the Evidence Act, accused can inspect the original, and it is also in conformity with the retention of electronic record which is provided in section 7 of the Information Technology Act, and which clearly says that the data can be accessed on a subsequent reference. So the purpose of giving the access is to ascertain the authenticity of the electronic record if it is challenged. So the accused have a right under section 207 of the CRPC to inspect the original. And in the civil proceeding, an application can be filed under Order 11, Rule 12 of the CPC. And the last issue which we are going to discuss is whether certificate under section 65B can be filed later on after the original evidence ceased to exist. So the first thing is certificate under section 65B can be filed at any stage. And the second issue is whether the original needs to exist. Yes, as we have already discussed, that the condition mentioned in section 65B subsection 2 are regarding the original electronic evidence. So that means at the time of issuing the certificate, we are giving the certificate relating to the authenticity of the original evidence in manner in which it is created, the manner in which it is preserved, manner in which we have obtained the secondary evidence. So original should exist at the time of giving a certificate under section 65B of the Evidence Act. Now, if a person issues a certificate very well knowing that original does not exist, that amounts to fabrication of an evidence, and it is a punishable offence under section 193 and 195 of the Indian Penal Code. So the person who is giving such certificate even can be prosecuted under these provisions. So these are some of the queries. If you have any other queries, please send me, then we can discuss it later on. Thank you very much.